With us now is a man who is well versed in the litigation process regarding environmental issues. Dick Stoll is an attorney with Foley Lardner. He is a partner and involved in the environmental practice there. He is also formerly with the EPA Office of General Counsel, where he helped develop the clean air regulations. And Dick, good to have you back with us here on Clean Skies
Tyler,
News.
glad to be here.
We're focusing right now on the endangerment finding simply because it was finalized in mid-December and already lawsuits are beginning to take shape.
Right. Actually, the way it works under the Clean Air Act, once EPA issues a final rule, which they did, I think it's in the Federal Register of December 15th, you have 60 days to file judicial review litigation in the D.C. Circuit. And we've already seen a few suits filed, even though the deadline is not till February 16th. There's already been a few suits filed, and we can expect a lot more.
What's going on right now before we get to February? What is taking place, and how are these shaping up?
With the regulations now?
With the lawsuits.
Okay, with the lawsuits. Okay. Well, first of all, unless somebody goes in and tries to get what you would call a stay pending review, which is really extraordinary and very difficult, really nothing's going to happen for a while, because the court has to wait now during this 60-day period. People have 60 days to file a petition for review. So at least for the first 60 days, we'll just wait and see who else is coming in. Once the 60-day deadline runs, you'll have a slew of lawsuits there. Then the court starts a procedure by which they try to organize the parties. There'll probably be some environmental groups suing on this, asking for more. This almost always happens. You'll have a lot of industry, you'll have a lot of states. The court will go through a process of aligning the parties, and then there'll be briefing and oral argument. This all takes a lot of time. But at least for the next, for the next 6 weeks, not much is going to happen. I should say that there are also people filing administrative petitions for reconsideration on the endangerment finding. Okay. In addition to the fact that you can go to court, sometimes people, if there's an argument that perhaps EPA didn't consider things that were actually, that should have been in the record, you can file an administrative petition for reconsideration. And parties have already done that. And this goes to some of these ClimateGate emails.
Right,
and the argument there is that EPA didn't have enough time once these ClimateGate emails came out. And they came out just literally a few weeks before the endangerment finding. And so now the argument that these administrative petitioners are making is that EPA has to reconsider the whole thing based on this new record with all these new emails. Now EPA is fighting that, and EPA doesn't want to do that. But the reason I mention that could even delay the litigation more, because it'll take a while to get that all ironed out. And what I've seen in other cases, when these administrative petitions are pending, that delays the litigation in the D.C. Circuit even more.
Gets very complex very quickly.
Yeah.
Let's talk about the D.C. Circuit's options. Vacate, remand, uphold. And this is not for the endangerment finding overall. It can pull out bits and pieces, correct?
Correct. Once the court finally looks at this, and I would say it could be 2 years from now before we get a ruling out of the D.C. Circuit on this, the court could just say everything's fine, it's upheld. And one thing to remember, by the way, while review is going on, the rule stays in place. Now, a lot of people get confused on that. Unless somebody does one of these extraordinary things and gets a stay pending review, which is really hard to get, then while the judicial review is going on, the rule stays in place. Okay, so 2 years from now, the D.C. Circuit might uphold the entire thing completely, or they might find bits and pieces of it to throw out. And when the D.C. Circuit reviews EPA's rules, it often throws parts of them out. It often throws all of them out. That's called vacature. It vacates the rules. Another option the court might have is say, well, perhaps they'll remand a rule for EPA to reconsider things, but while the reconsideration is going in place, the rule stays in place.
Let's talk through those 2 years, Dick, that process you were discussing. What happens when, and how do we get to 24 months from now?
Okay. First of all, again, we'll wait now for the next few weeks to see who all comes into this litigation. The deadline's February 16th. Then the court will try to align the parties based on, environmentalists, states, industry. There'll be several aligned. They'll try to get joint briefs. They'll try to get parties to agree on a schedule for joint briefs, agree on page limits and so forth. This all takes a lot of time. Then finally, briefs will be filed, and there's a round of briefing. The petitioners will file a brief. EPA files a response, the petitioners file a reply, but then everybody starts responding to everybody else because there's a lot of different parties doing a lot of different things, saying a lot of different things. Finally, there'll be an oral argument. On a complex case like this, sometimes the court will set an all morning for an oral argument. It's a 3-judge panel of the D.C. Circuit, by the way. There's 13 judges on the D.C. Circuit. By lot, 3 will be picked. There'll be an oral argument before this 3-judge panel. I'm going to say right now that may be 18 months from now. And then about 6 months after that, usually after the oral argument, you get an opinion from the court, and that's either when they're going to vacate or uphold or vacate in part or remand in part or whatever.
Within your circles, Dick, does the D.C. Circuit Court have a certain stereotype in terms of leaning one way or the other on environmental issues?
Over the last 30 years, it's moved back and forth. For a while, when I was at EPA in the 70s, the D.C. Circuit was considered to be a fairly environmentalist-friendly court. But that's waxed and waned. And right now, there's just different judges on there who have very different philosophical bents. And frankly, it could depend on the panel. It could, there's 13 judges on there. Some have been appointed by Republicans, some have been appointed by Democrats. Some of them are not particularly doctrinaire, some of them are. And so it may depend on just by lot who the 3 judges are as to which way this might come out.
So 2012, say we get our decision, something comes forward, that's 2 years from now.
Yes.
Then whoever loses or doesn't agree with what was decided moves forward. Is the Supreme Court the next stop?
Yes. There is a procedure where you can, I said there's 13 judges on the D.C. Circuit and 3 will decide it. There is a way that you can ask all 13 judges to review that. Again, that's very rarely granted, but there's one little step like that before you go to the Supreme Court. Otherwise, you go to the Supreme Court.
Does that, in some senses, echo in your mind, Dick, the 2007 decision on the Clean Air Act? Will it be that revisited altogether?
It would be a totally different issue then. What the Supreme Court decided in Massachusetts versus EPA in 2007 was whether carbon dioxide and other greenhouse gases were pollutants, were air pollutants under the Clean Air Act, and or whether they could be. And what the Supreme Court said is that if EPA makes this endangerment finding, which they're required to make, then it will be a pollutant under the Act. Now the issue would be, has EPA been arbitrary or capricious? Has EPA, is the science there for the endangerment finding? Now, and the courts tip EPA's way on close questions. So the court won't look at the science ab initio and just sort of say, whoa, wait a minute, we're going to read all this science and we're going to decide ourselves. They'll defer to EPA's judgment. But still they'll have to look at the entire record and make sure EPA's connected the dots, to use a popular phrase these days.
From what you've seen in the endangerment finding from the EPA, is there one especially large hole that some of these opponents will focus in on?
I think the most interesting issue that might come before the D.C. Circuit on this is not so much the science, but the fact that there are other requirements in the law that EPA has to consider the impacts of what it does whenever it comes out with some kind of major rule and major finding. And industry has been arguing on this, that EPA actually really didn't do an impact analysis on this endangerment finding. And EPA is saying, well, we'll do that later when we ever do real rules. Because remember, the endangerment finding is not a rule per se. It's not a regulation that requires anybody to do anything. But on the other hand, it sets in motion amazing consequences over the next years. The industry argument there is that EPA should have done various types of impact analyses that are required by statutes and executive orders to support its endangerment finding. EPA said, no, we're not going to do it. I think that's where EPA may be most vulnerable when the D.C. Circuit reviews the endangerment finding. The science, you could argue the science till you're, you know how that goes.
Right.
Everybody has their views on the science, but courts typically defer to agencies on scientific decisions as long as the agency has taken the comments in and, quote, connected the dots.
Dick, final question. Looking ahead to potential intersection of litigation and legislation. Again, move forward to 2012. If a climate bill passes this year, if a cap and trade were to be enacted, it would start in roughly 2012. That seems to be the language we're dealing with right now. What happens then if this is still a pending court case, yet legislation has begun? Does that supersede any EPA regulation?
Of course it depends.
Right.
And it depends on the legislation. But the intent of Waxman-Markey, the intent of the Boxer-Kerry bill, the intent of most legislation that EPA is supporting, that the administration is supporting, would be that these regulations would go by the by, that they wouldn't have to make their endangerment finding, they wouldn't have to litigate the endangerment finding. Most of these regulations that EPA is now moving forward on right now under the Clean Act would be under the Clean Air Act would be unnecessary. They would be superseded by the legislation. Now maybe there'd be some kind of minor legislation that'd come along that wasn't comprehensive, like Waxman-Markey or like Boxer-Kerry, and maybe that legislation wouldn't supersede what EPA is doing right now. But the kind of legislation that EPA hopes gets enacted would supersede these regulations pretty much totally.
I get the feeling this will be a continuing conversation in the months and maybe years to come. Dick Stoll is a partner with Foley Lardner here in Washington and a former member of the EPA Office of General Counsel. Dick, it's always good to have you with us. Thanks so much.
Okay, Tyler, thanks.